In a seismic 6-3 decision on June 27, 2025, the U.S. Supreme Court curbed the power of federal judges to issue nationwide injunctions, handing President Donald Trump a major win in his push to redefine birthright citizenship. The ruling, which avoided the constitutionality of Trump's executive order, reshapes the balance between the judiciary and the executive, sparking fierce debate across political lines. Trump's January 2025 order aims to reinterpret the 14th Amendment's Citizenship Clause, denying automatic citizenship to U.S.-born children of undocumented immigrants or those on temporary visas. Framed by supporters as a curb on anchor babies, it faces opposition from 22 Democratic-led states and immigrant rights groups, who argue it violates the Constitution's guarantee that all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States. Critics, including liberal justices, say this clause is clear, with exceptions only for groups like foreign diplomats. The court, led by Justice Amy Coney Barrett, focused on procedure, not substance. It ruled that nationwide injunctions, used by lower courts to block Trump's policy nationwide, exceed judicial authority. A universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power, Barrett wrote. Now, injunctions are limited to case-specific plaintiffs, allowing Trump's order to take effect in 28 states within 30 days, pending further challenges. Trump, joined by Attorney General Pam Bondi in a White House briefing, called it a monumental victory for the Constitution, separation of powers, and rule of law. Supporters, including conservative lawmakers, see it as a check on judicial overreach, freeing the executive to act on immigration. Critics, however, warn of unchecked presidential power. Justice Sonia Sotomayor's dissent called the ruling a grave attack on our system of law, cautioning that it endangers rights like gun ownership or religious freedom. She argued Trump's order is patently unlawful under precedents like United States v. Wong Kim Ark 1898, which upheld citizenship for U.S.-born children of non-citizens. The decision creates a patchwork system. Trump's order may apply in some states but not others, potentially tying citizenship to geography. Justice Brett Kavanaugh, concurring, noted the risks, saying a nationally uniform answer is preferable to avoid chaos, where a child's status depends on their birthplace. This could complicate benefits, voting rights, and hospital protocols. For instance, a child born in Texas might not be a citizen, while one born in California could be. Immigrant rights groups acted swiftly. The ACLU and National Immigrant Justice Center filed a class action suit for pregnant immigrants and their U.S.-born children, seeking broader relief. This is a core American right, said ACLU's Cecilia Wong. Legal experts predict the Supreme Court will rule on the order's constitutionality by 2026, given its losses in lower courts. Public opinion is split. A June 2025 NPR/Ipsos poll found 28% support ending birthright citizenship, with 52% opposed. Critics warn of a growing undocumented population, potentially 2.7 million by 2045, per the Migration Policy Institute, and stateless children, per immigration lawyer Alex Kuick. Supporters like Senator Lindsey Graham, who introduced the Birthright Citizenship Act of 2025, argue it deters illegal migration. The ruling's broader impact empowers the executive branch. By limiting injunctions, it slows judicial checks on controversial policies, affecting not just immigration but future actions on issues like healthcare or gun control. Justice Elena Kagan warned of a catch-me-if-you-can system, where only those with resources to sue can seek justice. Lower courts, now tasked with issuing equitable injunctions, face uncertainty, but the path to nationwide blocks is narrower.